Sorry about that, Tim. I ran into.
That's all right. It's okay. I can't find M911.
Need some help on some of those images.
I can't find. I know I.
That's what I thought. I was like, yes. I heard the first one yesterday, so they. Issue guys. Are we good to start? Did you guys have any updates on each other? Is there typos you caught?
Yeah, I was gonna check too.
Okay, we'll do it. We'll do it in the back then.
Okay.
That way we can have our,
Like misspellings. I didn't.
To be honest with you, I didn't read
look
it.
from the script.
Okay, but nothing jumped out at least. Okay.
But we didn't, I didn't.
Got it, understood. Yeah, I'll call him right now.
okay, great, thank you.
Yeah, you
Friend.
Yeah, since there's been references to the prior trial, I think it would be appropriate for there to be language in there saying something to the effect of, there was a previous trial in this case, and you were instructed that it has, or to disregard it. I think there was language in the memorandum that I filed that they've used in other cases.
Oh, yeah, I'll throw it on.
Was that on the
Previous trial memorandum. Okay, well, Mark-
Not from Italy?
It's trial memorandum, if you.
Off from Italy?
I think that,
of the folders?
yeah.
The leather market was pretty fine. Yeah, I told them we could just come back here. I was gonna check with them on those typos and stuff.
Yeah.
I'll need a minute to check something.
Oh, okay.
If you can. Do you guys have any typos or anything, on the spelling? You still want us back there?
Yes.
Okay. You guys wanna call her and come?
Give Megan a minute, but,
Finish that up.
Sure.
okay.
Let me,
Oh, yeah, take your
get the restroom and.
Okay.
No, I'm good, thanks.
Get your stuff there. Well, instructions.
This is my grab. Oh, yes, today is Blue Day, actually. See? It's Wednesday, we wear pajamas. That's like dirty, like. Okay, that's what you said.
I had to think of the miles. It's okay.
Yeah.
All right, thank you. This one. Everyone.
Did you get that email?
Yeah, I did.
There's no OTI in that discussion.
Go ahead.
You could set it up over in front of you, Gary.
Everyone could have a
I
seat.
don't think so. That cord doesn't reach.
Is there a board in there? Well, then just,
Yeah, there's no cord.
then just move them.
Carmen walked in first, so everyone thought when he said all rise, it was for her.
I don't know wrong with you.
The cord is there.
Back on the record, 21 CR 5052, State of Ohio versus Michael Jason Meade. Do we need to put anything on the record prior to bringing in the jury?
No, Your Honor.
Not from the defense, Your Honor, no.
All right, let's go get the jury.
I think.
Is this, do you need this?
There. Where's the
36.
Okay, pull that one. This one.
Sets. Let's get the volume.
Oh, that's Jack here. Jack.
All rise.
And both of them need audio. On the other ones, okay, take that one out now.
Everyone can have a seat. Ladies and gentlemen, what we're going to do today is I'm going to provide you with the jury instructions, and I will afford the state and defense an opportunity to make closing arguments, and then I will end up with a couple more jury instructions. My wife hates to be read to, and so I'm going to give each of you the jury instructions so you can read along with me. All right? All right, members of the jury, you've heard the evidence and will hear the arguments of counsel. The court and the jury have separate functions. You decide the disputed facts and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the laws that are given to you. You are not permitted to change the law or to apply your own conception of what you think the law should be. A criminal case begins with the filing of an indictment. The indictment informs the defendant that he has been charged with an offense. Or the fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charges and puts in issue all the essential elements of the offenses. The defendant is presumed innocent unless guilt is established beyond a reasonable doubt. The defendant must be acquitted of an offense unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offenses. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of their own affairs. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, and the facts agreed to by counsel. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which the witness testifies. It includes exhibits admitted in the evidence during the trial and stipulations of fact agreed to by counsel. Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of people. To infer or to make an inference is to reach a reasonable conclusion of fact which you may but are not required to make from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. You may not make one inference from another inference, but you may draw more than one inference from the same facts or circumstances. Direct evidence, direct and circumstantial evidence are of equal weight. You may consider both direct and circumstantial evidence. You must decide all direct and circumstantial evidence taken together with whether the state has proven all the elements of the charged offenses beyond a reasonable doubt. The evidence does not include the indictment or any statements made by counsel during the trial unless such statement was an admission or agreement of certain facts. The opening statements and closing arguments are not evidence. They are designed to assist you in evaluating the evidence. The evidence does not include any statements or answers that were stricken by the court or that you were instructed to disregard. Stricken statements or answers must be treated as though you've never heard them. You must not speculate why an objection was sustained to any question or what the answer to that question might have been. You must not draw any inference or speculate on the truth of any suggested included in a question that was not answered. A number of exhibits and testimony relating to them have been introduced throughout the trial. You will decide what weight, if any, the exhibits should be given in light of all the evidence. These exhibits may include, but are limited to, documents, reports, video, audio exhibits, and other physical items. The numbering or lettering of the exhibits that you take to the jury room may not follow consecutively. There are several reasons for this. An exhibit may not have been submitted by the party who produced it during the trial, or the court may not have admitted an exhibit because of a legal or procedural reason or ruling. Do not draw any inference because you do not have a particular exhibit. You will have in the jury room the verdict forms and all the exhibits received into evidence during the course of the trial. You will not be given any other exhibits during your deliberations, including trial transcripts. The lawyers are permitted to stipulate that certain facts exist. This means both sides agree that those facts do exist and are part of the evidence. You are to treat a stipulation as any other evidence. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You will use the test of truthfulness that you use in your daily lives. These tests include the appearance of each witness upon the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, the witness's accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Use these tests and assign to each witness such weight as you think proper. You are not required to believe the testimony of any witness simply because the witness was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of an issue. Rather, the final test in judging evidence should be the force and weight of the evidence, regardless of the number of witnesses on each side who testify to an issue. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. Also, discrepancies in a witness's testimony or between their testimony and that of others, if any, does not necessarily mean that you should disbelieve the witness. People commonly forget facts or recall them differently after the passage of time. You are all aware of the fact that two people are witnesses to an incident may often see or hear it differently. In considering a discrepancy of any witness, you should consider whether such difference concerns an important fact or a trivial one. Generally, a witness may not express an opinion. However, one engaged in a particular profession may express their opinion because of their education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. As with other witnesses, upon you alone rests the duty deciding what weight should be given to the testimony of the experts. In determining its weight, you may take into consideration their skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to the testimony. Hypothetical questions which instructed the expert to assume that certain facts were true and to give an opinion based upon such assumptions have been asked. You must determine whether the assumed facts upon which the expert based their opinion are true. If any assumed fact was not established, you will determine its effect upon the opinion of the expert. It is not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that the defendant did not testify must not be considered for any purpose. The charges set forth in each count of the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count, uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all of the alleged offenses charged in the case. The court will now outline and define the specific issues involved in this case. Count 1. The defendant is charged with murder in count 1 of the indictment. Before you can find the defendant guilty of murder, you must find that the state has proved beyond a reasonable doubt that on or about the 4th day of December 2020 in Franklin County, Ohio, the defendant caused the death of Casey Goodson Jr. as a proximate result of the defendant's committing or attempting to commit felonious assault, an offense of violence, and a felony of the first or second degree. Before you can find the defendant was committing or attempting to commit a felonious assault, you must find beyond a reasonable doubt that the defendant knowingly caused serious physical harm to Casey Goodson Jr. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all of the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant awareness of the high probability that serious physical harm could result from his actions. Cause is an essential element of the offense of murder. Cause is an act or failure to act that is a natural and continuous sequence directly producing the death and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or failure to act. Serious physical harm to person means any of the following: any mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment, any physical harm that carries a substantial risk of death, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity, any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement, any physical harm that involves acute pain of such duration as to result in substantial suffering or that involves any degree of prolonged or intractable pain. The defendant maintains that his use of deadly force against Casey Goodson Jr. was reasonable and lawful in the exercise of his official duties as a police officer and therefore justified because he feared that the actions of Casey Goodson Jr. would cause death or serious physical harm to the defendant. To establish this defense of justification, the defendant must prove that he was justified in using deadly force by a preponderance of the evidence. Preponderance of the evidence is a greater weight of the evidence. That is, evidence that you believe because it outweighs or overbalances in your minds the evidence that opposed to it. Now, preponderance means evidence that is more probable, more persuasive, or of greater probative value. It is a quality of evidence that must be weighed. Quality may or may not be identical with quantity. In determining whether or not an issue has been proved by a preponderance of the evidence, you should consider all the evidence bearing upon that issue, regardless of who produced it. If the weight of the evidence is equally balanced, or if you are unable to determine which side of an issue has the preponderance, then the defendant has not established such defense. If the defendant fails to establish the defense of justification, the state must still prove to you beyond a reasonable doubt all the essential elements of the crime charged. Deadly force means any force that carries a substantial risk that will probably result in the death of any person. The standard of law to be applied in determining whether the use or deadly force by a police officer is justified is as follows. Deadly force may be used if the offender or if the officer reasonably believes that such force is necessary to defend himself from the actual use or imminent use of physical force by the suspect that poses a threat of death or serious physical harm. If such circumstances exist, then the officer's use of deadly force is reasonable. The test of reasonableness requires careful attention to the facts and circumstances, including but not limited to the severity of the crime that the defendant police officer was addressing, whether Casey Goodson Jr. posed an immediate threat to the safety of the defendant police officer or others, and whether Casey Goodson Jr. was actively resisting arrest or attempting to evade arrest by flight. The test of reasonableness of a particular use of force must be justified from the perspective of a reasonable officer on the scene, standing in the defendant's officer's shoes, perceiving he then perceived and acting within the limits of his knowledge or information as it then existed, rather than with 20/20 vision of hindsight. The determination of reasonableness must allow for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. The test of reasonableness is not capable of precise definition or mechanical application. The reasonableness inquiry is an objective one. The question is whether an officer's action were objectively reasonable in light of all the facts and circumstances confronting him, without regard to his underlying intent or motivation. The objectively reasonable officer can be mistaken. Even if the officer had a mistaken belief, as long as that mistaken belief is reasonable under the then existent circumstances, the officer is justified in using deadly force. If you find that the officer held a reasonable but mistaken belief as to the facts that prompted him to act, then the officer is justified and your verdict must be not guilty. If you find that the state proved each element of the considered offense beyond a reasonable doubt, and the defendant did not prove justification by a preponderance of the evidence, your verdict must be guilty. However, if you find the state has failed to prove beyond a reasonable doubt all the essential elements of the crime of murder, or if you find that the defendant has proven the affirmative defense of justification by a preponderance of the evidence, your verdict as to count one must be not guilty. Count two, the defendant is charged with reckless homicide in count two of the indictment. Before you can find the defendant guilty of reckless homicide, you must find that the state has proven beyond a reasonable doubt that on or about the 4th day of December 2020 in Franklin County, Ohio, the defendant recklessly caused the death of Casey Goodson Jr. A person acts recklessly when heedless indifference to the consequences. The person disregards the substantial or unjustified risk that the person's conduct is likely to cause a certain result or is likely to be of a certain nature. A person is reckless with respect to circumstances when, with heedless indifference to the consequences, the person disregards a substantial and unjustified risk that such circumstances are likely to exist. Substantial risk means a strong possibility as contrasted with a remote or significant possibility that a certain result may occur or certain circumstances may exist. Cause has previously been defined. The defendant is alleging the affirmative defense of justification in count 2. To establish the defense of justification, the defendant must prove that he was justified in using deadly force by a preponderance of the evidence. Preponderance of the evidence, deadly force, and reasonableness have previously been explained for you. If you find that the defendant proved each element of the considered offense beyond a reasonable doubt, the defendant did not prove justification by preponderance of the evidence, your verdict must be guilty. However, if you find the state failed to prove beyond a reasonable doubt all the essential elements of the crime of reckless homicide, or if you find that the defendant has proven the affirmative defense of justification by a preponderance of the evidence, your verdict must be your verdict as to count 2 must be not guilty. I will read the verdict forms. You are not to place any emphasis on the order in which I read them. You will have 4 verdict forms. And here's the verdict forms. You can see there's a case caption, State of Ohio versus Michael Jason Meade. First verdict, we the jury upon our oaths and law and evidence in this case find the defendant guilty of murder as charged in count 1 of the indictment. Signed this blank day of May 2026 by each and every juror. You'll see 12 signature lines. Next verdict, same case caption. We, the jury, upon our oaths and law and evidence in this case, find the defendant not guilty of murder as charged in count 1 of the indictment. Signed this blank day of May 2026 by each and every juror. And again, you'll see there's 12 signature lines. Third verdict, we the jury upon, same case caption, we the jury upon our oaths and law and evidence in this case find the defendant guilty of reckless homicide as charged in count 2 of the indictment. Signed this blank day of May 2026 by each and every juror. And you'll see there's 12 signature lines. Last verdict form, same case caption, we the jury upon our oaths and law and evidence in this case find the defendant not guilty of reckless homicide as charged in count 2 of the indictment. Signed this blank day of May 2026 by each and every juror. You may not discuss or consider the subject of punishment. Your duty is confined to the determination of guilt or innocence of the defendant. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon the court. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your findings with intelligence and impartiality and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that their case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication of the court's view on the facts, you are instructed to disregard. Is there any closing arguments on behalf of the state?
Yes, Your Honor, may I have a moment to
You may.
set up? Which I'm going to need to screen down. Yeah, I've got it. Please, court, counsel, ladies and gentlemen of the jury. 6 shots in the back. That's what this case is about. No matter how Mr. Nolder, Mr. Collins twist and turn with the pointer, it comes back to 6 shots in the back. The state has the burden of proof, as the judge has just told you, meaning we have the duty to go forward. And we have. We brought you a total of, I think, 19 witnesses. You're going to have close to 200 items, or maybe in excess of 200 items. I haven't actually counted them all, counting the pictures individually. Back there in the jury room with you. You're going to have the door. And I submit to you that the question in this case isn't whether the state has proven its case. We've proven the offenses. Judge just gave you the definition for the 2 offenses charged. And I submit to you that we have established, by proof beyond a reasonable doubt, all the elements of each charge. That in count 1, Mr. Meade knowingly caused serious physical harm to Casey Goodson that resulted in his death. Now, we've heard over and over again, because most of the witnesses were police officers, and they're trained and universally trained, that when they fire their weapon, they fire it to stop the threat. And over again, we heard, you're not trained to commit felonious assault. But pointing a weapon at someone, regardless of your purpose, and the judge has told you it doesn't matter what the purpose is knowingly, and firing it at that person is knowingly causing serious physical harm when you strike the person. So regardless of whether the purpose is to stop the threat, it's still felonious assault. So don't be hoodwinked by any kind of an argument that, hey, the firing of a weapon by a police officer is just to stop the threat. That's felonious assault. And when it causes death, and the firing is not justified, that's murder. And understand that police officers do not have the right to fire their weapons just because there is a threat or a risk. A risk is the potential of a threat. That doesn't justify firing your weapon. And a threat has to be 2 things. It has to be immediate, imminent, and it has to be a threat of serious physical harm or death to the police officer or to someone else. Otherwise, firing the gun is not justified. Otherwise, it's moved from proper law enforcement to a criminal act. So what's this case really come down to? It comes down to whether the discharging of his weapon, whether Mr. Meade's firing that weapon 6 times, and we don't know whether it was in automatic mode or semi-automatic. So we don't know whether he pulled the trigger once. We don't know whether if it was in automatic and he followed the conventional training of firing in bursts. He fired it twice. It's interesting that you got 3-3 in the groupings of the shots. We don't know because he didn't tell us in his statement. His detailed statement that was to explain in minute detail, he left out whether it was on automatic or semi-automatic. But we do know he fired 6 bullets out of that weapon. And whether he did it in a full automatic mode or a semi-automatic mode doesn't change the fact that that weapon, his firing of that weapon, caused the death of Casey Goodson. The question in the case is, was the firing of the weapon justified? And that burden isn't on the state of Ohio to establish that. That burden rests on the defense. They have the burden to prove to you by a preponderance of the evidence that the shooting was justified. If it's a tie, if when you evaluate everything, you determine, gee, I'm just not sure, I don't know, they lose. They haven't established it because it's by a preponderance. It's not by equal evidence. It's not by some evidence. It's by a preponderance of the evidence. Judge has just told you about the defense of justification. And it can be confusing because the defense involves what the particular officer knew and the facts and circumstances around that, but it is not his mindset It's that of an objectively reasonable officer. If it was just what the officer said, then every shooting would be justified, because every officer is going to tell you, well, then, I had to shoot because of this, this, and this. So you have to evaluate from the evidence that's presented what a reasonably objective officer would have concluded. So how do you decide that? You decide it by evaluating all the evidence and comparing and contrasting it. There were two use of force experts presented to you. Mr. Scanlon, who was a police officer for, I believe, 33 years. And he brought forth his testimony based upon his experiences as a working police officer for 33 years. And Professor Stoughton, who was a police officer in the patrol area for about 5 years, I believe he said, and then he became an investigator, but still in a police-like role for about 5 or 6 years. But then he moved on into an academic career. And so he's the academic who studies policing, who evaluates policing. And they had the disagreements between them had to do with the tactics that were employed, the decisions made up until the shooting. But interestingly, their opinions are identical relative to the shooting. Both of them told you that if in fact you determine from all the evidence that Casey Goodson turned and pointed his gun at the defendant, the shooting is justified. Case over. But likewise, both of them told you that if the evidence does not support that finding, that if the evidence doesn't establish that Casey Goodson turned and pointed his weapon at the defendant, the shooting is not justified. And at that point, your verdict has to be guilty. So, taking all the complex, which we lawyers can make everything complex, no offense, but taking all the complexities in the instructions, what it boils down to from your standpoint is, has the evidence established that Casey turned and pointed his gun at the defendant? That's what the case boils down to. So, what evidence has been produced that that's what Casey did? That he turned and pointed? Well, you have the written statement of the defendant. And you'll have it back there. You can study it. And it goes into detail about his training and about, you know, he has good eyesight and all of these different things. And then it says, and he says on page 10 of his statement, talking about Mr. Goodson. But the moment after his shoulders drooped, he, Mr. Goodson, Casey, quickly turned his head and torso in my, Mr. Meade's, direction to confirm my location, while he suddenly and unexpectedly started to raise his right arm back. As he did so, I saw he was still holding the gun, raising the barrel upwards in my direction. Okay. There's some evidence that he turned and pointed the gun. What other evidence is there? Well, the only other evidence that exists is arguably the testimony of Dr. Desmullen, who told you, didn't tell you it had happened, told you it was possible. Because remember, we know that this door was between the defendant, Casey Goodson. And how do we know that? 3 bullet holes in the screen, an impact point at the top of the screen. Physical evidence. Something important to remember when you're evaluating the evidence in this case. Physical evidence doesn't lie. It just is. Physical evidence can't be untruthful. It just is. People lie. People are lying. Physical evidence has no motivation. It just is. People have motivation. Motivation to tell the truth. Or motivation not to tell the truth. Those are things that you're going to have to take into consideration. And when you evaluate Mr. Meade's written statement, you will need to take that into consideration. Is it truthful? Is it accurate? Well, we know one area it's not accurate. Mr. Meade described this encounter at the intersection of Carl and Ferris Road. He says, I looked right north to ensure the road was clear, and I saw a dark-colored hatchback driving southbound on Carl Road. The vehicle approached the intersection in the left-hand lane, signaling, turn signal, that he was turning left east on Ferris Road. The vehicle stopped. That's what he said. The vehicle stopped. He didn't say it slowed. He said it stopped. He went on to wait for the northbound traffic to clear. So what he's saying is there's cars coming northbound. You know, we've all made left-hand turns. We know that, you know, you can't turn in front of somebody if they're coming through the intersection that you're turning in. So the vehicle stopped to wait for northbound traffic to clear. And as it did so, I saw the driver had a black handgun with an extended magazine in his right hand. He had the gun raised above the steering wheel, held it sideways. Now, bear in mind, he's got it in his right hand. Mr. Meade is located to the left. He said, held it sideways, i.e. palm down. So this extended clip, which emerges maybe an inch or two out of the gun, he says he could see when it's palm down holding sideways. Of course, he saw it later on the underneath Mr. Goodson when he turned him over. Palm down, aimed towards the windshield. He was repeatedly straightening his arm and forward, such that he was pumping the gun towards the windshield, then pulling it back. He appeared to be yelling as he pumped the gun, but I could not tell what, if anything he was saying. Okay, pumping the gun, appears to be yelling. A lot of activity right there as he stopped at the waiting to turn. A car traveling northbound on Carl Road approached the intersection. Approached, not in the intersection, not clearing the intersection, but approached the intersection. And the individual aimed the gun at the driver of the car. So now he's either, aiming. The individual tracked the driver with the gun as the car traveled north, but I could not see whether the driver reacted to the gun. So he's saying, car's coming, he's tracking it like that as he comes all the way through the intersection. Play 13A.
I apologize, Tim. Our password. You're gonna put the password back in. It's not working. Was it working one? Oh, working two.
My colleague can get the computer working. So let's watch what what he just described in his written statement. So stop. He didn't stop. The car that was in the intersection was exiting the intersection as Casey is approaching. This is his detailed statement. What do we know? We know this came January 4th to the investigators. We can also probably assume that Mr. Meade had no awareness that there was a video of this interaction. Is that truthful? Who's got a motivation here to deceive? Physical evidence doesn't lie. People do. So what evidence is there against the idea that, or the suggestion that Casey turned and pointed the gun? Well, we can start with, he's got 6 shots in his back. They're not in his front. They're not in his side. Well, yeah, there's one that's kind of in the far left side, back side. You've seen the wound. But think about that. Because they're going to talk OODA and all this. If there's going to be a shot in the side, wouldn't it be the shot that's the side that's turning towards? What do we know about the shots? Well, they're kind of grouped. You got the upper shots and the lower shots. And Dr. Shepler said to you, I can't tell you what order they came in. I don't know what shot number 1, 2, or 3 is. She labeled them as she examined them, and nobody's maintaining that the labels are the absolute order they came in. But there's several things that we can probably reasonably conclude from her examination. First conclusion that I think we can make is that the 3 upper shots, mid-back, left mid-back, or upper back, I'm sorry, midline. And then, you have, this might be easier if I just hold up. Okay. All right. We got this grouping up here. These 2 shots, she said, would have caused like spinal shock, which would have at least momentarily paralyzed his legs, causing him to fall. These 3 lower shots you have a sharp angle, upward angle and a sharp upward angle there. How do you get those? He's got to be bent over, like falling. And I think it's reasonable to conclude that if he was bent over when he was shot, and those are the first shots, he didn't then straighten up to get the upper shot. So here are the first ones. These are the last ones. Okay. All right. I don't want to belabor things too long. You will have all the evidence. You can look at it closely. You also have Dr. Bauer's testimony. I know you were all attentive during that. And he places Casey inside the kitchen, not in the doorway. We know that there's no damage to the doorway other than the storm door, and that all the bullets go on into the kitchen. Casey's keys are in the door. We've got a Subway bag that we know he was carrying because he bought it 5 minutes before. That's laying on the floor off to the left of the position that he comes to rest on the floor. We have the gun under his chest. Remember, Officer Rosser said it was under his chest. Is that consistent with it being in his hands? We know the bag was in his hands. Is that under his chest? Is that underneath him? It's off to the side. If the gun's in his hands, and we know he had to open the door, so you need to have the keys to do that, because the keys are still in the door. Pretty soon you run out of hands. So I'd submit that the physical evidence suggests that the gun wasn't in his hands, that it was in a flimsy holster that was in his belt. You have even Dr. DeMullen says, the lower shots that they match up with the holes in the storm door, and the level has to be at the kitchen. So he's got him kind of teetering, as he steps in, because once you're in the kitchen, how do you turn and point the gun around the door to become this imminent threat? You can't. Dr. Bauer tried to do it in his, all of his different programming and stuff, and he said, I just couldn't make things line up. Mr. DeMullen makes it line up, but he's got him with his left foot on the threshold and his right foot hanging out here in space. And Dr. Bauer told you about how, from a biomechanic standpoint, when you step up, all the weight is on the foot you're stepping up on. How do you then turn and reach around the door? Physical evidence doesn't lie, ladies and gentlemen. People do. That's what this case comes down to. Have they proven that he turned and pointed the gun? They have to rely on Mr. Meade's statement. That certainly discussing the initial encounter is grossly inaccurate. grossly. I mean, that's not a small mistake. He's embellished it. Just like doesn't bother to, you know, he's going to rely on, I got a little placard on my vest and somebody's going to see it from 100 yards away. He wants to be, if he's, as he's pursuing, the smart tactical move is let him know you're a police officer. He's got a light package, and you saw the video of what that looks like. He doesn't use it. But after the shooting, while they're still trying to clear the house to get the medics in, what the heck is he doing? Is he trying to get the medics in? He's going to hold the medics as he goes across the yard and flicks on his lights. Why would you do that? Is that perhaps a sign of recognizing, whoa, this wasn't a good shoot? Is that I want to be able to cover things up? I want to be able to say that I had my lights on? Body cam doesn't lie. Physical evidence doesn't lie. People do. I'm gonna wrap up here, ladies and gentlemen. There's a lot more I could say, but we want to be judicious in our time, and I'm going to sit down and let the defense get up here. But I want to leave you with one thing, because there is another statement from Mr. Meade, and I submit to you it's a bit more accurate. And that was on the porch on that day that was caught by Seth Penny, the Minerva Park police officer, on his body cam when Mr. Meade is speaking with another officer, and the other officer says, "Hey, I missed the call. You know, what happened?" And then Mr. Meade steps off the porch to tell family members that they need to go down further in the yard, and he comes back up. You got it queued up there, Gary.
Mm-hmm. We need to. I hope this sounds ready.
Yes.
They're saying that it's their nephew. He came out the street, gun in his hand, going to the side door, going in with a gun. You guys were pulling out? Yes, as I was pulling up. Yeah, Joey asked first to go to this. Who's in charge here? I was one of the commissioner.
Notice what he said there? You know, what happened? Did he say, the guy turned and pointed his gun at me. I didn't have a choice. No. He said he pulled up with a gun, coming from the street, gun in his hand, as I was pulling up. Their own expert told you that's not justification. Evaluate all the evidence. I've only touched on some of it. There's a lot more. Ask yourself, if Casey was going to turn and point the gun, why would he?
Basis?
May we approach?
Ready?
Ladies and gentlemen, there's other evidence. You know what it is. We've tried to be meticulous in presenting it. I leave you with this. Does it make sense that someone is going to point a weapon with safety on? Does that make sense to you? That's how the gun was recovered. And I haven't even talked about the AirPods, YouTube music. All of those things are there for your consideration. I submit to you, ladies and gentlemen, that when you evaluate all the evidence, you will conclude that the defense has not proven that Casey Goodson turned and pointed the gun, and that the physical evidence establishes not only that he didn't do that, but that he wasn't even aware Mr. Meade was there. Thank you.
Ladies and gentlemen, we're going to take a break. Otherwise, Carmen will scream and yell at me. About a 15-minute break. I guess I have to read this still. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. About 15 minutes.
All right.
Ask yourself, why would someone point
I
a
figured you needed a break for.
point a gun? See what I was gonna say. Why would I can say, yeah. Oh, thank you, Mark. Clumsy fingers. Please have a seat. Oh, you the one that announced it?
Do we sit?
She didn't give you
She didn't give us
permission.
the orders to sit. I can sit.
Welcome to my world. Gary, I think this is yours. I don't know what you want. Get stuff away that you're not gonna use.
I just want to make sure you see.
Yeah, we're just making, yeah, that way.
Thank you so much.
Uh-huh. No, we're gonna this week, one actually.
I got it. Okay.
Oh, I appreciate it.
Yeah, I mean,
I guess this is okay.
Yeah.
yes, please. I need to make an extra. No, we're not. We're not gonna take a break for someone to move, it's, you have to move down. I mean, you said where you need to go, but the process, we have to make it extra space.
Thank you so much.
Thank you.
That is cool. Yeah, you're good. Thank you so
And they
much.
know to go on next.
Thank you.
Back on the record, 21 CR 5052, State of Ohio versus Michael Jason Meade. Do we need to put anything on the record prior to bringing in the jury? No, Your Honor. No, Your Honor. Good jury.
All rise.
Everyone can have a seat. Any closing argument on behalf of the defense?
May I proceed, Your Honor?
You may.
Thank you. May it please the court, Madam Court Reporter, Madam Balloff, Mr. Schroyer, Mr. Merkel, Caitlin, Jason, and Stephen Mulder. Good morning, ladies and gentlemen of the jury. In the beginning of this case, you said you took an oath, and you stood up and you swore not to form any opinions, conclusions, until you heard all the evidence, the closing arguments, the and the instructions of law. We've been a little busy, but we've tried to watch you. And I believe you've kept that duty and met the oath. And for that, I thank you. I thank you because without you doing that, we wouldn't have the best criminal justice system in the world. Without your civic duty, we wouldn't have the best system. So from all of us, we thank you for your service. December 4th, 2020, ladies and gentlemen, was a tragic day. The Goodson family lost a son, a grandson, a brother, a nephew, a cousin. Their family will be affected for the rest of their lives from their loss. December 4th, 2020 affects all of us in this courtroom. Each of us will take a piece of that with us for the rest of our life. It's an example of an action and a reaction affecting so many people. But your role here, ladies and gentlemen, as a juror, goes far beyond your sincere belief of the empathy for this situation. When you step back to that jury room, ladies and gentlemen, the call of justice and your legal duty requires you to set aside the understandable sympathy and empathy that you have as human beings for the loss in this situation. But that's why you have to follow the law and the judge's instructions and keep your oath. December 4th, 2020, not the defendant, but Jason Meade. He has a name. Jason Meade was doing his job. Jason Meade, it's a simple case, ladies and gentlemen, it really is. Jason Meade was doing his job the way he was trained to do. He was investigating someone, a male, who pointed a gun at him and was waving a gun. Casey Goodson, for whatever reason, just like Ms. Stevens told you in opening, for whatever reason, turned with that gun towards him. And Jason Meade defended himself based on his training and protected himself. The government, through hindsight, and the government, through selective misrepresentation, puts all these other facts there. The basic concept of the facts were he was investigating what he saw, and he was placed in a life or death situation by the actions of Mr. Goodson. With those facts and the jury instructions that you have, your verdict will be, even though it's hard, that you must acquit Jason Meade of these actions. Now, there's a basic analysis in the framework of those jury instructions. We talked about it in voir dire. They have a burden of proof beyond a reasonable doubt. Proof of such nature, you rely upon it in the most important of your own affairs. A surgery for a child, care for an elderly parent, one of the most important decisions of your life. A first, a second, a third opinion, ladies and gentlemen. That's the type of proof beyond a reasonable doubt. And that burden never shifts. It stays with them the entire time, ladies and gentlemen. It never shifts. If for some reason you believe they met their burden, then we welcome the burden shifting to us of proof beyond a preponderance, more likely than not, a feather touching a scale. Yes, I think that's the case. Yes, I think so. And our burden, more likely than not, actually trumps the higher burden. Doesn't make a lot of sense, but that's the way our legislature does it. If they don't meet their burden, it's not guilty. And even if they do meet their burden, we do, it's not guilty. Now, closing arguments. It's a time to bring up some inferences, apply them to facts, point things out to you. And there's three common themes in the government's case. Three common things that run through the entire thing. Lack of context, low quality of evidence, and misrepresentation. All three. And when you look at those, you can call them each different thing, but what they amount to, each and every example, and there's many, but I'm only going to focus on a few. Each and every example is a building block of reasonable doubt. Each and every example in and of itself is enough to prove that they didn't meet their burden, because it's a building block of reasonable doubt, and it will get higher and higher, ladies and gentlemen. First one, they don't give you anything in context. They take everything and take it out of context. And what I mean by that, ladies and gentlemen, is then we have to put it into context for you. Because in order to make an informed choice here, you need the full picture. You need the entire context of the situation. This case is about context. The government doesn't want to provide it. They openly resist the opportunity when it's apparently appropriate to do. We have to provide the contrast. Example, you just saw it in closing. They started their case in opening. The first thing Mr. Merkel said was 6 shots in the back. The first thing Mr. Merkel said in his closing was 6 shots in the back. That's all they have, ladies and gentlemen, okay? But that's all, that's where they stop. Because someone got shot in the back, therefore it must not be justified, okay? Now, they don't even start from the interaction. The law will tell you that you have to start at the initial interaction of your analysis where Mr. Goodson and Mr. Jason Meade's paths crossed, where they became intersected, at that intersection. They start at the end. That's all they have. They just showed the video. Think about what it confirmed. The car position, Jason's first position. What happened? He saw what he saw and he did a U-turn. All of that was confirmed in the video. He pulled over to States. That was confirmed by Rosser. The full picture, ladies and gentlemen. And it's amazing what the government does. Mr. Merkel is an attorney. You heard from Dr. Shepler, an expert on wound paths and trajectories. And she told you, with a person with 6 shots in the back, right to left, upward, and back to front, can be consistent with someone turning this way. That's because the projectiles are
Overruled the closing arguments.
exactly the testimony. It's not that complicated. You can still have 6 shots in the back and not be facing directly across from them. You can still have 6 shots from the back and be turned this way because it comes from over there. Right to left, upward, and back to front. Somehow, Mr. Merkel, now, Doctor, we asked the coroner, can you tell the order? Absolutely not. We asked Dr. Bauer, can you tell the order of the shots? Absolutely not. Dr. DeMuller, can you tell the order? Absolutely not. 2 of them are their experts. And Mr. Merkel just got up here and told you, don't listen to their evidence with the experts. Listen to me because I believe these happened at this time because that's why the body's bent over here like that. Again, they add their own context. It's disingenuous. What did Dr. Shepler say? I can't tell you in any way, shape, or form how the body was positioned. And if anybody does, they're giving you crap. Again, a building block of reasonable doubt, ladies and gentlemen. No matter what, Mr. Merkel claims to be now a coroner and a biomechanic expert. Example 2, they hit this one in their closing. The Seth Penny video. They can't help themselves, ladies and gentlemen. Where did they start that in the case in chief? At the 38-second mark. They don't even include the part with the question. They don't, because they don't care what the question was. They don't want to give it context. They only want the answer because that answer fits their narrative. They started from a premise of 6 shots in the back and worked backwards. And that's when it doesn't make sense, ladies and gentlemen. Who provided you context to that? Geez, we did in our questions of, Mr. Nolder did in our questions of Officer Rippey. Hey, I'm going to play you the full video. Do you hear the question that was asked? Yes. How'd I miss the call? Okay, what did you observe next? He's trying to answer. He's keeping people off the street. He's telling, hey, is the scene clear for the medics? All the different things. Comes back and says, it was a U.S. Marshals channel. They leave that out just now. It was on the U.S. Marshal channel. That's how you missed the call. Was the question, why did you fire? No. Was the question, tell me why you pulled the trigger? No. The question that was answered, he was trying to answer to was, how'd I miss the call? And somehow they distort that.
Objection, Your Honor.
Overruled closing arguments.
Somehow, they have to distort it because it doesn't fit their narrative of 6 shots in the back, of what was happening. Geez, Jason Meade is supposed to say to anyone who comes up there, hey, this is why I pulled the trigger. You heard plenty of testimony from officers. They're trained not to do that. They don't ask the person. You heard from Inspector Youngless, very impressive guy. 2 things. Are you okay? And did you fire? Yes. Answer the questions. Hey, how did I miss the call? He answered the question. They don't even have the courtesy to give you the question that was asked. We had to. Example 3, Dr. Bauer. This is the epitome of giving you evidence without context. They actually had Dr. Bauer testify about 5 slides that Dr. Mullen talked about. How on earth can you testify about something if you weren't in the courtroom listening? How can you try to give an opinion? The audacity of Dr. Bauer to say, well, I have a picture. This must be what he meant. Mr. Noldo asked Dr. Bauer, did you listen to his testimony? No. Again, they take out of context of 5 pictures. And they have someone comment who has no idea. How many times did Mr. Schroyer ask Dr. Mullen over and over again, hey, on this picture number 4, were you trying to show this? No. Hey, on this picture over here, were you trying to show that? No, you're mistaken. Hey, what were you using this slide to do this? Why did he put a foot in the air? Because in Jason Meade's statement, he said, I saw him stepping up to the threshold. He's just trying to test the hypothesis. Could he have been in this threshold? And even though Mr. Merkel misstated it, he said it's more likely that he was. He had it, he tied it to the 3 bullets, he did the anchoring, and he said, yes, it's more likely that he was in the threshold. That's the hypothesis. More likely, based on a reasonable degree of biomechanical certainty. Example 4, Detective Hughes. By January 2021, Jason Meade had given his words, given his statement of his perceptions and his beliefs and his fears that occurred on December 4th. A month later, without seeing a video, without knowing what witnesses said, without knowing any of that stuff, based on his memory, okay? His observations. Jason didn't have to give that statement. And what did we talk to Detective Hughes about? Detective Hughes, you'll have the email back there, was invited. If you have any questions, please ask us from the lawyer. If you want to talk to Jason, please let us know. If you have any concerns, all of a sudden, Detective Hughes has concerns, right? Did Detective Hughes do anything when he got that statement if he had these concerns? No. Days became months, months became years, and 5.5 years later, even though prior testimony at the hearing, he had the opportunity under oath to talk about his concerns. There's never a written report. There's never a document of any of that concerns, but he had concerns. 5.5 years later, because it doesn't fit in their narrative now, that's why he has to have concerns. Again, part of the context. You don't get many chances. A good detective reads the stuff, compares, they say, geez, I got some questions, I got some issues. Gee, I wonder if I've been asked can I talk to you? It was an open invite, ladies and gentlemen. Full context is following up. And it's especially the case here because he testified under oath before and he never said a word. The first time ever to people was to you. That's what happens when you start from a premise of 6 shots in the back. And that's all you have. Another example of the government putting stuff out of context. And again, all of these are individual building blocks of reasonable doubt. And that's their burden. Beyond it. Dr. Bauer's need to place Casey Goodson into the kitchen to make his math work. Okay? What do we know, ladies and gentlemen? What do we know? He likes angles and he likes measurements. They show a picture to him from the Rippy video that shows Mr. Goodson's feet there at the end of the doorway. Mr. Nolder said, hey, Dr. Bauer, did you do that analysis? Did you do the measurements? No. You could have, right? He chose not to, all right? He could have, and he even said, Dr. Brown said, well, the momentum probably moved him to there from the fall, which actually places him closer to the threshold. And Dr. Bauer said, I've reviewed all these things and all these objective materials. Yes, I consider those. Hundreds of documents. And the reason we asked him about it's the first time he's ever testified in a criminal trial is because in a criminal trial, in the justice system, you hear 911 calls. And you heard a 911 call. Remember what he said to Mr. Mulder? I don't remember if I heard that or not. I don't remember if I heard that or not. Ladies and gentlemen, that 911 call is haunting. You won't forget it. And he's an expert, but you know why he has to disregard it and not give you the full context? You know why, ladies and gentlemen? Ms. Stevens?
At my house, he lives here with me.
So who shot him?
I don't know. I just
Okay.
heard the gunshots and I would get up and he's laying in the door.
Okay.
He's laying in the door. This is the first civilian. And the first observation she has, remember, she hears the chandelier clashing. She runs out there past Ernest and she looks around. And unfortunately, she was there that day. And unfortunately, she has to see her grandson laying face down at the time with his arms like that. And as soon as she picks up the phone to call 911, what does she say? He was laying in the door. Not in the kitchen, not in the doorway, in the door. How else does she corroborate that? She was their very first witness. May I have the Elmo? This is where she puts him, in the door. That's her writing that Mr. Merkel had on that. In the door, in the threshold. But that doesn't fit Dr. Bauer's narrative, and his math, and his model, and his surrogate. So that's why he doesn't consider it. That's why he didn't remember the 911 call. When you have your first witness on the scene say, in the door, why else, ladies and gentlemen? She didn't need a surrogate to convey what she saw. She didn't need to be paid a king's ransom like Dr. Bauer to try to say what he saw. Unfortunately, she was there. But who corroborates what she said? You're going to have Exhibit 27 back there, Jason Meade's words and observations and beliefs and fears. And in that, he says, I couldn't close the door. The body was there. I couldn't, the door wouldn't close. Objection.
Overruled. Closing arguments.
It's in the statement that the door couldn't close. He then pulls him and rolls him over. The door couldn't close because he's in the threshold because his feet are there, ladies and gentlemen. And he's pulled over from the front to the back, ladies and gentlemen. Dr. Bauer doesn't even know that. He just has got him laying in the back as momentum took him there. He doesn't even read the reporter, Jason Meade's statement that he rolled him over. Who else corroborates that besides Sharon Payne and Jason Meade? Jenny Jones, again, comes running out, not sure, looks over. She can only see Casey's hands like this in his eyes. Cannot see anything below the chest area because it's out in the doorway. It's in the door. It's in the threshold. Now, let's use your common sense, ladies and gentlemen. Common sense, right? Where was most of the glass found from the storm door? On the step. On the step on the porch. You'll have many pictures of it back there. Okay? So if the door is closed, ladies and gentlemen, all right, and the glass goes, the projectiles come this way, the glass is going to be inside the door, inside the kitchen. If the door is open, ladies and gentlemen, if it's pulled to be open and it's resting on somebody, okay, like Jason Meade said, read the statement, was resting against the door. The door was resting against it. And the projectiles come through here. Where's the glass going to be? Using your common sense. On the stoop. On the stoop. That's collaboration using your common sense. Not a 3D model. That's just basic, ladies and gentlemen. But they don't want to give that to you. They only give you part of the concept. Again, another building block of reasonable doubt. Part Partial content, the junk science by Dr. Bauer. Again, partial, out of it, angles and measurements. At a prior hearing, he was asked, can you give us the amount of feet that your model put into the kitchen? That's the issue, whether it's into the kitchen or on the threshold. Yeah, I'll get it for you. Does he give it? No. Can you give us the angle that you put the door being open or closed? Yeah, I'll get it to you under oath. Does he do it? No. To you, he says, oh, I sent the whole thing to you guys. At any time did Dr. Bauer turn to you and said, this is how many feet I placed Casey Goods in the kitchen in my model? No. At any time did he say, this is where I had the angle of the screen door? No. And they would even ask him. It's cross-examination. Mr. Norman's like, hey, you never gave me that information. It's a wordplay and stuff like that. All they had to do is turn to you and say, this is how many feet I had the model into the kitchen. He can't, because that blows up his whole theory, ladies and gentlemen. He can't. We provided the full context. Remember, keep this in mind, Dr. Bauer has everything flat. Everything flat, even though everyone who testified about trajectory, when it goes through an intermediate object, okay, it can wobble, it can change direction, it can fall, they call it tumble, and it can fragment. You heard a lot about fragmenting, right? Not to Dr. Bauer. It's got to be straight, because it's got to fit his science. Even Professor Stoughton's direct testimony, where did he start it at? The sales estates. That's the first question they asked him about on December 4th actions. He doesn't start up at the intersection, even though he told you correctly that your analysis is confined to from the time at the intersection where they had interaction until the time that the use of force is done. Nothing before, nothing after. He agreed to that. He confirmed the totality of it. Again, we had to bring out the intersection with him. And what did he say? At the end of his testimony yesterday on the cross, he said, well, yeah, obviously he reacted to something. That's why he did the U-turn. No, but they think, they got to tell you he made it up. They got to tell you that he's lying about seeing the gun at the intersection. Again, another building block of reasonable doubt. Quality of the state's evidence. Call it what you want, quality. Let's talk about this. I was wrong in voir dire. I didn't think anyone would lie. You witnessed a pure example of lying put on by these two people. They put
Overruled, closing arguments.
the government called Chris Korn to the stand. All right, let's look at this. The government called Chris Korn to the stand after he's already watched prior testimony at a hearing, right? And let's look at what he told you. Well, I saw someone dancing, raising his arm, maybe singing, but I didn't see a gun. They have to have that narrative out there that he didn't see a gun, because then maybe you won't think that Jason saw a gun, a trained officer at spot number 1. They have to do that. Ladies and gentlemen, it's so easy. When you look at that video that Mr. Merkel just showed, that van is still moving as Casey Goodson comes by him. I submit to you that when you're driving and you're going forward and you're stopping, you're looking where you're stopping. This guy wanted some fame from the prior testimony, okay? You're looking forward. And then what did he describe? He described an afro. We know that's not the case because we know there's a skull cap and a hoodie. Oh, no, wait, not an afro, a ponytail. You can't see a ponytail off the hoodie stuff. I thought it was a female at first. He actually said that. Still moving forward. The worst part, ladies and gentlemen, the biggest hypocrisy of this case about lying. Physical evidence doesn't lie. The glass on the door doesn't lie. Chris Korn lies, and he got caught in 2 of them. The first one, ladies and gentlemen, he deletes his evidence before his FBI interview. Doesn't tell them, okay? He deletes it. Geez, now we got to come up with a reason why he deleted it, okay? Mr. Nolder asked him, hey, did you have any contact with the Goodson family? Tamala Payne. Nope. Mr. Nolder's like, well, the prior hearing, you said you contacted them 4 or 5 times. Not sure. Are you kidding me? Let's take it one step further. Mr. Schroeder, not once but twice, asked Mr. Korn, why did you delete your social media before talking to the FBI? You know what he said? I was getting so many friend requests. Too many friend requests. Okay. All right. That's okay to me until you get to the evidence, ladies and gentlemen. Until you get to the evidence. Perjury is making a statement knowing it's false under oath. Another type of perjury is making two statements under oath that aren't consistent, okay? He did both. One, when he said, oh, no, I've never contacted him. Oh, in a prior hearing, he said I contacted him 4 or 5 times. But then we're back to, why'd you delete your social media? Too many friend requests. The government's expert, Detective Howe, provided 4 reports. Did the government talk about report number 4? Hell no. Ms. Stevens brought it out. And it's pretty simple, ladies and gentlemen, because Detective Howe does a report, sends it to them, and then they send it to us. So either they didn't read the report or they didn't care and asked him that question. Because when Ms. Stevens asked Detective Howe, hey, did you do analysis that shows whether or not he had any friend requests prior to him deleting the information, right? You remember that? The answer was, yeah, I did the analysis. Were there any friend requests? No. That's their evidence. That's their expert who says there is that he received no friend requests during that time period. And ladies and gentlemen, they knew that, but they still put up a liar and asked the liar that question. That's a building block of reasonable doubt. That's low quality evidence. I don't know if it's incompetence. I don't know what it is. But when you have information that says there is no evidence of a friend request and you give it to us, and we see it and we ask their expert that question, they already know the answer to. That's how desperate they are in this case, because all they have is 6 shots in the back. Second one, the quality of evidence, the AirPods. Mr. Merkel didn't get a chance to talk about it. The AirPods, let's talk about it. All this stuff about what was playing on the phone, right? And things like that. Why do they do that? Of course, Jason Meade didn't know he had AirPods. He had a skull cap on there, right? And of course, you're not supposed to consider that, okay? Because he didn't know it, so you don't consider that. But they have to do that. And then in that situation, ladies and gentlemen, they want you to believe that what was playing on the phone was coming through the AirPods. It's in report number 4 again. They gave it to us. And Ms. Stevens very effectively said, Detective Howe, is there any data that you saw confirming that what was playing on the phone came through the AirPods? I cannot, it did not. There is no data. Within a reasonable degree of scientific assertion, there is no data. But yet they still put forth that evidence to try to get you to think, why would he do this? Why would he do that? AirPods, he must not have heard. Again, and it's disingenuous because their own evidence that they gave to us shows that there's no data. You can see if it happens or not. There was no data showing that it was playing in the AirPods. That's their case. Next one, Detective Hughes. Penny's body-worn camera. I asked Detective Hughes, you were concerned with what he said at the porch? He goes, yeah. Did you go interview Officer Phillips? That's who asked the question. No. Well, then wouldn't you want to have the person interviewed who asked the question? Hey, Officer Phillips, why'd you ask the question? What question did you ask? And were you okay with the answer? And Detective Phillips, did you ask why he shot? They used word names. How'd I miss the call? What happened? What happened? Oh, how'd I miss the call? Gee, he gave the answer, ladies and gentlemen, and it's factually correct. Detective Hughes, this is a good one. The Extended Magazine. The Extended Magazine. Their gun expert, Caleb Worley, expert in guns and rifles, said it's an extended magazine. Every single police officer they put on said it's an extended magazine. Everyone who Detective Hughes has admiration for and holds them in high regards said it's an extended magazine. But it doesn't fit their narrative because maybe if they say it's not an extended magazine, then if he's pointing and waving like that, Jason Meade couldn't have seen him. He's on an island. Detective Hughes is the only person from law enforcement who says, oh, I don't consider that an extended mag. Nice try. Nice try. Put yourself on an island against the people. Again, why? Let's get just right to it then. He just made an argument about a flimsy holster. Who's the person they asked about a flimsy holster to? The reason they had to ask Detective Hughes about the flimsy holster is because Detective Kroom said, I'd say the same holster I've used. I've run 100 times with it and it's never falling out. I've chased suspects, it's never falling out. Detective Kroom has it. They didn't like that answer because it doesn't fit their narrative. So what happens? They put Detective Hughes up there and says, hey, that's flimsy, right? And I'm like, well, geez, have you ever used it? No. Are you kidding me? They put a witness on the stand and asked him about the flimsiness of the holster. And Mr. Merkel just argued it. And they did it with a detective that's never had it, never used it. That's desperation, ladies and gentlemen, to fit the narrative. Let's talk, and again, those are all building blocks of reasonable doubt, ladies and gentlemen. Let's talk about misdirection. And he did it. They can't help themselves. The last question he asked, they did it. They try to play on your emotions. You know, and you have the instructions, you know that the instructions will direct you start the analysis at the time Jason Meade and Mr. Goodson first encountered one another at the intersection up until the time he discharges a service weapon. That makes common sense. You can't, if the officer didn't know something, you can't take it in the equation, okay? So, but why do they put all these things in? Because they want to play on your emotions. They're hoping you're inquisitive. And when I objected, he asked the question, why? That's what they want. They want you not to look at that time frame and apply the law of facts, but why? Why would Casey Goodson do something if he had the safety on? Nobody knows if the safety's on. It doesn't come into the equation. They know that. But yet that's what they're trying to do for proof beyond a reasonable doubt. That's what they're trying to do, ladies and gentlemen. You can't consider of it. Their own expert, Professor Stoughton, said, no, you can't consider, you can't, in your analysis is not to consider anything that the officer didn't know. The dental receipt, the AirPods, the subway receipt, the way Mr. Goodson parked the car because across from the fire hydrant, that's how the family parked the car. The front door not being used because it sticks. They use the side door. The dog's names, the floor plan. Safety on the gun. They can't help themselves. Their own expert told you you're not allowed to use that in your analysis. They just keep going. They just keep going. The CCW permit. Jeez, he has a CCW permit. Why would someone with a CCW permit be reckless and dangerous with a gun? A CCW, why? Okay, that's what they want you to think. But Jason Meade had no idea about it, so it doesn't come into your equation. But what do you know about it? You know that after he got the CCW permit, he had an accidental discharge in the kitchen with his grandmother and uncle there. He knows the grandmother testified he always takes his gun with him in the car all the time, and he doesn't put it up. And you know from the picture that Ms. Stevens showed in the post out there that he points the gun in the car. Misdirection, again, a building block of reasonable doubt. The holster we've covered, the CCW permit we covered. Okay, again, the so-called reenactment by FBI agent White. All right, hey, I'm trying to do the concept. Just be fair about it. Just give the full picture, right? What do? All right, where do they position the truck? They have no idea. They position it somewhere. Okay, we'll position it in that place, then move it 2 feet up, then move it 3 feet up, and do the same thing, right? Or move it back, but don't just do it from one spot because they can't say, they have to guesstimate where it is. No northbound traffic? They don't have any northbound traffic in their example. No matter what Mr. Merkel says, you see a northbound car clear the intersection before Mr. Goodson turns. It's there. You'll see it back there. They don't put that in there. And they put a mask on the person in the car. Jason Meade said he thought he was shouting, the person in the car. Chris Korn said he thought he was singing, but they put a mask on the person in the car. And ladies and gentlemen, it's coming from a camera. And you heard testimony that a camera doesn't catch what the human eye does. A human eye, when you look at something and you focus, you can focus in. A camera, you can't. It catches pixels. And you heard about the fisheye with the body-worn camera. You can't look. When you see something, ladies and gentlemen, if you see something in someone's hand, you zoom in on that. That's what the human eye does. The photograph that they use, remember that photograph from the street, right? At the end of the street, looking back down towards the car that Agent White talked about? Okay, in Jason Meade's statement, you will read, I pulled over near Sales and Estates, several houses north of the car, okay? The FBI agent used 7, okay? Did they put someone who's 6'2" standing outside the car in the picture? No. Did they do it from 7 houses? 1 means 1, a couple, or 2 means a couple. Several is 3, 4, 5, 6, etc. Again, take the picture from 6. Take the picture from 5 houses. Take the picture from 4 houses. Take the picture from 3 houses. Give it context. Give the full picture. They pick and choose what they want. They chose 380 feet away. That's not what Jason Meade said in his words. He said, I was several houses north. How do you navigate this misdirection? Ladies and gentlemen, you do it with common sense and you compare the physical evidence. Mr. Merkel talked about the physical evidence to the law. That's what you do. Example of common sense. You saw it. You heard Inspector Youngless talk about OODA. OODA, observe, orient, decide, and act, right? We had a perfect example of that. Mr. Scanlon talked about that as well. A perfect example. May I have the screen?
Each exhibit,
I'm sorry.
sorry.
Your Honor, objection.
Each exhibit, sorry.
Now pay attention. Watch Detective Williams observe the recklessness of Mr. Merkel.
Each exhibit,
He orientated.
sorry.
He decided, he acted. Okay, one more time, Ms. Stevens. The only recklessness in this trial was his handling of the weapon. Watch it. He's looking, oh, he points it at him.
Each exhibit,
Gets away.
sorry.
And Detective Williams knows that gun's not loaded. Detective Williams knows that gun can't be fired. But what you saw was I observed something. I orientated myself to it. I decided what to do and I acted. That's how they're trained, ladies and gentlemen. That's how law enforcement officers are trained. You heard Mr. Scanlon say, I can't stop the OODA, even in retirement. That's how important it is when a gun gets pointed at you, one in a safe setting with no ammunition. That's how an officer reacts. The glass on the boards, we talked, the holster, common sense. There's gun, there's blood and DNA on the gun, DNA on the trigger to one person. Is there any blood or anything on the holster? No. And on the clothing, it's underwear, it's pants, it's a shirt, it's a sweatshirt, all over it. They want you to think, oh, somehow this flimsy thing, Casey never had the gun in his hand, it flipped out somehow. But it didn't get any blood or anything on the holster. Misdirection. The coroner. Dr. Bauer in the corner. Dr. Bauer, 7 times I counted, said the trajectory was fairly flat. Flat. Fairly flat. Flat. Ladies and gentlemen, when you have that coroner's report back there, not one time will Dr. Shepler identify the path of the trajectory of the wounds as fairly flat or anything like that. They're all upward, some more significant than the others. But that's how Dr. Bauer has to couch it because he has to have that. He has to have the flat stuff. Minor injuries. Look at the coroner's report. You'll see minor injuries on the left hand, left forearm, the left back, down in there, part of the right thing up here, okay? Minor injuries, ladies and gentlemen. That's from the glass. So that's how you know that the door was on there, ladies and gentlemen. And where you won't find any, ladies and gentlemen, is on the right hand, the hand that had the gun. You won't find any in the coroner's report. Why, ladies and gentlemen? Because if the door is resting back here, okay, and I'm pointing back there, then my hand's out like that, ladies and gentlemen. I've turned, I'm on the threshold, I'm standing on the threshold, and the glass hits all of this area, ladies and gentlemen. And unlike what Dr. Bauer said, I don't have to turn my shoulder out here. That's what Jason Meade described. You saw the pictures of it, ladies and gentlemen. And the physical evidence matches. There is no injuries on the right hand. And both Dr. Bauer and Dr. DeMullin said, I can't tell you what's going on with the right hand. Common sense, it's your navigation. Common sense. Ladies and gentlemen, an important thing about the door is, I'll use this. Everybody said that, and you see it, that the trajectory went through the door, right? You see the bullet holes, right? And Dr. DeMullin testified to the spread. What do I mean by spread? The spread of those 3 shots, okay? Now, we know there were 6 shots. We know all 6 hit the body. okay? Now, the closer, this is the intervening object. The closer the object is to those holes, the more likely they're gonna hit. The farther the object is away, meaning Mr. Goodson, the less likely they're gonna strike the body. It's just basic thing. Put a hole through there, when you go back there, put a hole through there. All 6 hit. The farther you go away, ladies and gentlemen, the less likely that it's gonna hit the body. That's just basic common sense, ladies and gentlemen. They don't want you to use your common sense. Because it contradicts Bauer, because it puts him closer to the threshold and not farther. Ladies and gentlemen, the government's theory in this case is that somehow Jason Meade is a mentalist. He's either a mentalist because they want you to believe he didn't see the gun. Okay, I know this guy's got a gun, even though I didn't see it. So within 5 seconds, I'm gonna do a U-turn. I'm gonna do this U-turn because I know he's got a gun and I'm gonna go arrest him for it, right? No, ladies and gentlemen. He did the U-turn because he saw it. The other thing is, it's a cover-up. They put forth a theory that it's a cover-up, that Jason Meade walked out to the truck to put his lights on. Hey, here's a reason, because we asked people, do you sometimes go out and put your light on when medics are coming in? The answer was yes. That's the reason, but it's a cover-up, says Mr. Merkel. Wow, cover-up, you know what that means? That he made it up. He made everything up. Geez, I think the guy's got a gun, so I'm gonna go, and I'm gonna air it to my team. I'm gonna tell my team, who respects me and I respect them, I'm gonna tell my team and lie about what I saw, even though I describe it. Even though at the scene, a gun is found. Wow, he's the luckiest person in the world. But now I'm gonna walk around and I'm gonna make this up. Geez, I'm stuck, I gotta cover up. That's what, ladies and gentlemen. He doesn't know that Sheila Staniford was interviewed. He doesn't know what Ryan Rosser's gonna say. He doesn't know that Sheila Staniford confirms all his commands. He doesn't know that Ryan Rosser confirms what he told him at the intersection of Sales and States. So you can't have a cover-up unless they're all involved. And they can't be involved because Jason Meade has no idea who Sheila Staniford is. But that's their theory. That's how desperate they are. They say Jason Meade made this up because he's a mentalist and he wanted to shoot someone in the back because he thinks he had a gun. They're doing this to someone who served their country honorably in the Marines. Someone who did 11 combat missions, not time, 11 combat missions, who's trained to do that. Someone, ladies and gentlemen, who dedicated his life to the community as a Franklin County Sheriff's deputy. Someone who then was on the SWAT team and also on the SOFAST federal team. That's somebody who lies. That's what they want you to believe. Semper Fi, ladies and gentlemen. Semper Fi. You know what it means? It's a quote for the Marines. It means always faithful.
Overruled. Closing argument.
Always faithful. Once you're a Marine, you're always a Marine. And you don't lie. They don't put you in those situations for 11 tactical combat missions if you're a liar. They don't do that. But they're saying he's lying because he has to cover up. That's their theory of the case. But we know it's not the case, ladies and gentlemen. 10 pages of words, perceptions, and thoughts and beliefs. And each and every part of that was corroborated. But one word, stopped versus slowed. The video clearly shows he didn't stop. He's mistaken about that. There's 1,993 words in there, and they've pointed out one word that he's incorrect on. Are you kidding me? Each and every part. Let's go through it. His position at the intersection. He says in his statement he was in the first position. He was. And again, he doesn't know the video's there. Somehow they think the video hurts Jason Meade. Thank God the video's there because it confirms everything he wrote in his statement from memory. First there, he had an unobstructed view of right and left. The direction Mr. Goodson came, he came down this way. The traffic clearing the opposite direction, confirmed. The U-turn that was Jason's reaction to Casey Goodson's actions, confirmed. Slowing and telling Rosser. Rosser tells you this. He slowed down to tell me the guy's got a gun. You see that on the video. Pulling over at Estates. That's confirmed by Rosser. Putting his vest on, confirmed by Rosser, and you saw the pictures after the fact. Pointing out the person in the car, out of the car. Rosser doesn't see the gun. Hey, there's a guy in the car. He's out of the car. There's a guy with a gun. Rosser doesn't see it. He's not looking for it. Rosser's still trying to figure out what's going on, he tells you. The fleeing. This is the fleeing. Rosser and another described different ways of the person fleeing. But guess what, ladies and gentlemen? You heard the sworn testimony of Sheila Stanford. She said, I know Casey Goodson, and I saw him running from somebody. It's corroborated. And Jason Meade, if he's going to cover up, does he know somehow that they're all going to corroborate him? How dare they? Ladies and gentlemen, our burden, if you get there are so many blocks of reasonable doubt, ladies and gentlemen, we don't feel you have to go to the second analysis. But in all due respect, if you do, we have proven our case more likely than not. We have proven it through Inspector Youngless. We have proven it through Dr. Degulin. We have proven it through the sworn testimony of Sheila Stanford. And we've proven it through Jim Scanlon, as well as our cross-examinations of all the other evidence that they put forth. Disproving, adding context. 2 prongs we have to prove. The first prong is whether or not Jason had a belief that he was possibly facing a serious physical injury or death from a deadly weapon, okay? 92 people testified that if a weapon's pointed at your way, it's a deadly threat and they'd be fearful, right? It's pretty simple. But they made it even simpler for us because they proved it for us. Because we talk about in voir dire, whether to put your client on or not, well, when the government puts his full 10-page statement on, you don't have to. That's their evidence. They made his testimony. They made it evidence when they had our accused read it. They put his testimony in. And one word is all they have. Jason's own words, I was in fear for my life at the time I fired the weapon. Quote, I believed he intended to shoot me and that I would be killed. Quote, at the time I fired, I did not think I had any other reasonable option to protect my life and threat presented by the suspect's actions. Again, everything is dictated by the individual's actions. Action and reaction. Casey Goodson's gun was found underneath his torso when they turned him over. Did we prove more likely than not? Because that's our burden. Did he have a subjective belief? 100%, ladies and gentlemen. 100% more likely than not. Second one, how we prove the second prong. Now, again, I'm going to read it. You have it in your jury instructions. The second prong is reasonableness. Whether a reasonable officer stepping into the shoes of Jason and viewing or knowing what Jason knew at the time could believe the need to use deadly force in that situation. Not would they, but could they believe the need of that choice? And is that choice reasonable? All right? Now, how do we analyze that, the reasonableness? The Supreme Court, State v. White, gives us guidelines, and you will see them in the instructions. The first is the severity of the crime. There's 3 examples of the severity of the crime. The first is waving at the intersection. That's aggravated menacing. The second is when you pointed at someone, that's an attempted felonious assault. Also, improper handling of a firearm, which is a felony. Attempt felonious assault is a felony. And the last one is at the door. When the guard...
Overruled this closing argument.
Felonious assault is a felony of the 2nd degree. Attempted makes it a felony of the 3rd degree.
Outside the evidence, Your Honor, none of this is.
Overruled closing argument. Closing argument's not evidence. You can continue, Mr. Collins.
Thank you, Your Honor. Appreciate it. So again, ladies and gentlemen, the last thing, serious crime, is when at the doorway when he turns, when the suspect turns, when Mr. Goodson turns. Okay? Those are all severe crimes. Have we proven more likely than not that those? Yes, every single law enforcement officer told you they would have a duty to investigate, and it's a serious crime. It's a threat. Depending on what you do with a gun, it's a deadly threat, a potential threat. You name it, it's serious. More likely than not. Detective Hughes even swore an affidavit to that, ladies and gentlemen. He went in front of a judge and said, I swear that these facts are true to my knowledge. And it was somebody waving a gun in a car. That's a crime. The second Graham factor you'll see in the jury instructions was a suspect trying to evade or flee. Okay, what do we know about that? Well, you have Rosser testifying what he saw. The person started to walk, then picked up. Was he eluding you? Yes. Jason Meade words, he tells you what he sees. And who else corroborates that, ladies and gentlemen? Was the suspect attempting to flee? Sheila Stanford. I see him running. He was running from somebody. So we have proven more likely than not that second Graham factor, ladies and gentlemen. That's our burden. Now, the disturbing thing about Mr. Merkel's closing is this is what he said, that we had to prove for justification that Casey pointed the gun towards him. We don't have to prove that. We have to prove his actions were reasonable. and he misstates the law, we have to prove that Jason Meade's actions were reasonable. We don't prove anything about Casey Goodson, but they can't help themselves. They have to go there. U.S. Police, drop the gun, drop the gun, drop the gun. Corroborated by 2 other people. Ladies and gentlemen, consistency and cooperation and credibility, it's not a coincidence. It's not a coincidence when it's the truth. You can't be consistent and corroborate things and be credible if it's the truth, ladies and gentlemen, and it matches the physical evidence. Those grand factors will be there. Now you have to step into the shoes of Jason Meade. And in this situation, ladies and gentlemen, here you have to step into the shoes of someone pointing a gun at you, leveling a gun back towards you. Those are the shoes you step into. And who did we ask if they would respond? I would submit they're all reasonable. Detective Rosser, Sergeant Stanley, Officer Rippey, Officer Pinney, Marshal Youngless, Detective Williams from the FBI, Detective Kroom, Detective Hughes, FBI Agent White, even Scanlon and Stoughton both said, well, Stoughton said he hoped he would fire. Everybody else said they would fire. And everyone else would. Reasonable. Those are reasonable police officers. Ladies and gentlemen, each and every action we've shown in our case of what Jason Meade's actions were based on the actions of Mr. Goodson were reasonable. Let's go through them now. Let's compare the use of force, okay? Let's go through there. Did he believe he was going to be shot? His decision to use force was reasonable. Let's go. Ms. Stevens, can I have the chart? Let's compare Stoughton, their use of force expert, with Jim Scanlon. This is a comparison I'll take every day and twice on Sunday, ladies and gentlemen. Experience. Stoughton, 5 years. Scanlon, 33. Remember when Ms. Stevens asked Stoughton, hey, would you agree that someone with 5 years of experience versus 33 is not experienced? He said, yeah, I would agree with that. I don't think he knew he was talking about himself. Next one, training. Stoughton trains executives and higher ups, and oh, by the way, children in self-defense. That's what he does. Scanlon, thousands trained at all levels, ongoing, current, at every single level for 33 years. Jim Scanlon's been training, and then after that, when he had this consulting firm that went around the country to train people. Where training? None in Ohio ever for Stoughton, because he doesn't do that. Scanlon, extensive everywhere. Certified in Ohio, not Stoughton. Scanlon, yes. SWAT experience, not Stoughton. Scanlon, yes. Who do they train? This guy they put on trains first-year law students in criminal law and second-year law students in criminal procedure. And they want to compare him to Jim Scanlon? And this is the best part. He told the standards that they use. How many times did Mr. Scanlon say, I can only use the standard that's provided to me for my analysis? Their expert actually told you he was going to use a different standard than you use. Ms. Stevens.
Standard we're talking about here. I'm applying generally accepted practices, which is a different standard than, for example, what the jury is asked to provide, and a different standard.
There you go. They're expert applying a different standard. They don't even understand the standards. He told you on there, I'm using a different standard. Ladies and gentlemen, I had one job while he was testifying. I had one job. I had to count how many times Seth Stoughton on direct examination by Mr. Schroyer said the word tactic or tactical. I have a newfound love and compassion for what our court reporter does. 62 times he said the word tactic or tactical in the direct examination for Mr. Schroyer. 62 times. In your jury instructions, the word will not be in there once because you're not to consider those. But that's all they have, ladies and gentlemen. That's how they try to go to proof beyond a reasonable doubt. It's not in there, ladies and gentlemen. And then they go to the cover and the teamwork and the lights and sirens. And what did the reasonable experts say? There's a situation. The situation determines what you do. Sometimes you have the ability to take cover. Sometimes you have the ability to go slow. Other times, as Detective Hughes said, you got to be a cop. You go alone. You assume your team's following behind you. Sometimes you turn your lights and sirens on. Mr. Scanlon said in this situation, it would exaggerate the situation if he turned his lights and sirens on when he saw him out of the car, because they'll flee faster. No, they want one standard, a general standard. It doesn't happen. You won't see in the jury instructions risk-benefit analysis. The higher the risk, the higher the danger. Those are Stoughton's creations. They're not going to be in there. You will see in the instructions severity of the crime, immediacy of the threat, whether Mr. Goodson was evading arrest. We have proven more likely than not those factors, ladies and gentlemen. Ladies and gentlemen, he said academia and academic like 9 times. That's because he's an academic person. He's not a trainer. He's not up on a law. And there's a saying in the practice, ladies and gentlemen, those who do. Those who do the work, do the work. Those who can't, they become law professors because they can't do the work. Timing and reaction is a big thing in this case, ladies and gentlemen. The reason that Dr. DeMullen tells you that the response time that someone perceives a threat that they fire is between 0.32 and 0.86, okay? That's the test, depending on your training and stuff like that. Now, the reason he did the timing of a 22-year-old male who turning the torso was to go into his model. Is there time between the time someone reacts? Remember, Jason Meade says he steps to the left, someone reacts. Can you turn your torso one way or another? And the study says yes, it's 0.38, okay? So what that means is, and this is what we went over before, is I had him do it. Dr. Mullen's not saying that he was turning more to the right. He could be turning back to the left. He could be turning to the right. He could be here. But there's time from when someone sees the gun pointed at them, AKA Mr. Goodson from Jason Meade, that he could turn back this way. He could turn more that way. And it fits into the reaction time. That's what they don't understand. That's what Dr. Bauer couldn't comment because he was in the courtroom listening to what Dr. DeMullen said. Timing, Art Hughes. Go ahead, Ms. Stevens. Art Hughes asked me in a clip. Or anything, right?
Yes. Can you slow down a little bit too, please?
You got it. I apologize. Yeah, can you slow down a little bit, please? Art Hughes in a controlled setting gets to ask to slow down. You know who doesn't get to ask to slow down? Jason Meade. You know who doesn't get to hit the pause button? Jason Meade. You know who doesn't have the afforded that? Jason Meade. We did that as a group. Remember voir dire. That fits in between 0.32 and 0.86. That's how much time you have to react. Ladies and gentlemen, I told you in voir dire, sympathy and empathy. We ask you to be superhuman. We ask you to see someone lose their life, see life-saving measures being going on, see those coroner's pictures, but yet don't let it affect you. It's an improper thing of our court system. We ask too much from you. And all I can ask you is that if you feel yourself sympathy and empathy, if you feel yourself in the jury room, remember, go to the table with the law and the facts. Because you're going to feel that way. It's human nature. It just happens. But go to if you feel yourself saying, well, what about Casey Goodson's perspective? What about that? You got to go to the table that says you're not to include that. You're not to analyze that because that's a hard thing. But that's why he finishes with the safety. Why would someone fire a pointed gun if they had the safety on? It doesn't come into the analysis, ladies and gentlemen. I'm wrapping up, Your Honor. 5.5 years, Your Honor. 5.5 years, ladies and gentlemen, there was not one concern expressed about the Rippey video, about this, because it didn't fit their narrative. There was no report documenting the credibility of his concerns. The government believed it for 5.5 years. In the trial, the government claims Jason's words and perspective are not credible. However, 5.5 years, they believed his statement, words, and beliefs were credible. There was no memo to question it. There was no documentation, and it wasn't done in a prior under oath thing. 1,993 words that the government put in this case, in his statement, they chose to put in. It becomes his testimony. He was mistaken about one. The government wants to claim that 5.5 years of inaction. Think about this, the action of giving the statement, that's Jason Meade's action. Their reaction was nothing. Inaction for 5.5 years. Now, ladies and gentlemen, Your Honor, with the court's permission, I'd like to do a demonstration. And first, Your Honor, I'd like to ask Jason Meade to stand up, please. Come over here, Jason.
Objection, Your Honor.
Overruled, closing argument.
Your Honor, may we approach?
No.
All right, I'd like the jury to observe myself and Jason. Okay? Mr. Nolan, Ms. Stevens, yes. Now, this is a plastic gun, ladies and gentlemen. It's a plastic gun. It's been cleared by the deputies, okay? All right?
Your Honor, may we approach?
No. This is what blows their entire case in Dr. Bauer, okay? And the tape measure, please. Mr. Moaz. 65.3 inches. He says 65.3 inches was the level of the barrel. All right, when that rifle was fired, 65. He said it could be 66.3, and it could be 64.3. All right, those represent those three areas. Okay, Mr. Nolder, any question on that? No. Okay. All right, 65.3. There you go. Okay. Now, here's the problem. Dr. Bowers never fired the rifle. They don't understand that. He has him, Jason Meade, standing straight up. And he has him with his feet like this, all right? Never fired. He has no idea about the recoil. He has no idea about how it kicks, how it goes higher or lower, because he's never fired it. The Mullins fired it, Scanlon's fired it, and their FBI agent fired it. And what did they talk to you about the training, the techniques of that gun? You have to put it here, ladies and gentlemen. You have to put it here because of the kickback, the recoil they call it. You have to put it either in your pectoral muscle. Both Agent White described that as well as Jim Scanlon. You have to put it here because of the kickback. And how did Mr. Scanlon say they train people in the SWAT? They train people in this. They train with that walk, the isosceles triangle, walk and walk. What did Agent White say when you fire this? You have to lean into it, okay? Same exact thing that Mr. Scanlon did, this and this. Okay, ladies and gentlemen, this and this. Here, we're here. And remember, there's a sight on top of this. Okay, so I'm going to put this barrel, ladies and gentlemen, at 65.3 inches. All right, it'd be on top of my shoulder, ladies and gentlemen, and I'm taller than him that you just saw. And there's a sight there. There's a sight up top. I'd have to even go like this. 66.3, I'd be on my tippy toes, and I'm taller. And 64.3, there, that's level. Do the levels again. 64.3. 5.3, 6.3. Where's the butt of the gun? It's on the top of my shoulder. Mr. Scanlon said it would be impossible to fire from the top of your shoulder. Oh, you wouldn't be able to control it. That's why they put it here. And Jason had a vest on. It would be even higher. But Dr. Bauer doesn't understand that because he's never fired the weapon. That blows their entire map. Remember that floating gun that you saw? That floating gun in his pictures? He didn't put a figure there because he can't. Because it's impossible to fire that gun on the top of the shoulder, and you can discredit his entire testimony. They actually use a biomechanical expert on guns who never fired the gun. Same concept, ladies and gentlemen. That's how desperate they are. It defies common sense. The government wants you to judge this case from the screen, ladies and gentlemen. The screen. But the law requires that you judge this from the street where officers are, not what you see up on a screen. Why? On the screen, everything can be enlarged. Everything can be slowed down, made louder, replayed, enlarged, and most importantly, it can be criticized by them. On the street, Jason had to decide, ladies and gentlemen, whether the gun he had already seen twice, was going to be the gun that killed him. He had no pause button. He had no crystal ball, and he had no duty to wait for the first shot. The law does not require perfection from our law enforcement officers. It requires reasonableness, and we've proven that. Criticism of tactics that aren't in your jury instructions is not proof beyond a reasonable doubt. It's not. Even amid this tragedy, ladies and gentlemen, reasonable means lawful. Lawful means that Jason Meade is not guilty. I thank you for your time. I thank you for your effort. I thank you for your attention. And I wish you Godspeed in your deliberation. Thank you.
Any rebuttal?
Thank you.
Thank you, Your Honor. But we're back to in voir dire. The only evidence that you're to consider in here isn't what counsel say.
It's not what comes out of our mouths, it's what comes out of this courtroom, okay? The demonstration or whatever, you guys see it, all right? You know, holding the gun down here, you heard what they said. You gotta look through the sight. It's gotta be raised up. And there's the margin bears in these things, that's what Dr. Bauer had indicated. But let's just back up a little bit because there's a lot that I need to cover with you. Let's start with just common sense and credibility. And we do ask you to bring common sense that can be used to compare to what Mr. Meade claims is the truth. It's his credibility through that statement. You don't take his word for it, like what they're suggesting. You must test the credibility for truthfulness, just like anyone else. Just because he says he thinks something or whatever, it doesn't make it true. So when Mr. Collins says, you use only what Mr. Meade says or what he knows or what he saw or what he determines, whether you believe him and whether it fits the evidence is what you get to see using your common sense. You just don't take his word for it. And you do examine the totality of everything, unlike what Mr. Collins is trying to say. Don't look here, don't look there, okay? Only what Jason Meade says. That's all you can do, just take what Jason Meade says. That's not what you're to do. The jury instruction says you judge all the credibility, you look at all the evidence. When looking and evaluating the evidence, you must compare it to whether Mr. Meade's assertions even make sense. The jury instruction states that you will use tests of truthfulness, that you will in your daily lives, along with reasonableness of the testimony, reasonableness of the opportunity of the witness to see, hear, know things about what the witness has testified. In this case, the testify is his statement. The witness's accuracy, memory, frankness, lack of it, interest, bias, together with all the facts and circumstances surrounding the testimony. That's what you're going to be doing here. So let's back up to I think one of the first things that Mr. Collins brought up was the Seth Penny video. Now, when you guys get that back there, I want you to listen closely to the video, because in the video, okay, the Officer Phillips does say, I missed the call, but you listen to it. Then he says, what happened? That's the part that they've left out. The what happened. And that's where you'll hear, and that's when he comes on and he tells you what happened. The call is that, he came out of the house, or he came out of the car with a gun in hand. He's going into the house with a gun in hand. That's not what he was asked. He was asked what happened, and you watch the video. You'll have it back there, and you make that determination, because you'll hear that what happened. The convenient part that they leave out. They want to make you sound like he's just talking about the call. That's not the case. Now, it's kind of interesting that when they talk about Dr. Bauer and Dr. DeMolin, okay, they both put him up in the threshold. They both put him have to be standing up, because you heard the testimony from both of them. If he was standing on the porch, these holes don't fit. Nothing lines up. And in fact, if you also look at Mr. DeMolin's analysis, he doesn't even do the 3 holes in the back. Now, a lot of this was, look at what the state presented to you, what they presented to you. And he kept mentioning that they didn't meet their burden of proof beyond a reasonable doubt.
Well, Mr. Merkel was up here and you got the instructions. The only burden of proof that we have, or the burden of proof to prove the charges beyond a reasonable doubt, that he knowingly caused serious physical harm to Casey Goodson, and it was the proximate cause of his death. The other one, that he was reckless and heedless indifference and a perverse disregard, and it caused his death. His statement establishes that. His typed statement establishes those elements. He admits to all that in the statement. For him to sit there and then say, well, look at all this other evidence. They didn't meet their burden of proof beyond a reasonable doubt. That goes towards they've got the burden. They've got the burden to tell you and to prove to you by preponderance of the evidence that he was justified in shooting. And as you heard what the two use of force experts say, that if in fact Casey did turn and level the gun, and you'll have the statement back there. Listen, read how Mr. Meade describes it. He turned and raised and leveled the gun. Now, if that happened, then he was justified. Both Professor Stoughton and Mr. Scanlon both agree with that. And they both agree that if that didn't happen, if he didn't point the gun at him, it's not a reasonable. It wasn't an imminent threat, because it has to be an imminent threat of serious bodily harm or death. So let's put this back on track, okay? He can go through all the evidence that we put into this case, but he has to prove his side of the case. What evidence was there that his side of the case is truthful? What evidence in the case is there that the gun was even pointed at him? Is only Mr. Meade. He's the only one. So that's where you go and evaluate, test his statement when you go back there and read it. So let's move to the intersection. And I kind of looked at this, said it's a good thing that about the video, okay? There's this at the intersection of Carl and Ferris. Oh, it's a good thing they put in the video. That helps our case out. There's only one word in there, stop. Oh, that was some one word. Well, there's no evidence that he's changed it from stopped to slow. You read his statement. That was Mr. Collins testifying in here. There's nothing in there, that statement. When did he make this change? When did he change his testimony? You'll have a statement. It says stopped. You have no evidence before you that was changed to anything different other than counsel testifying here. Now, we do object, and the judge allows it in because the judge knows and expects you guys to follow the law, that that's not evidence. That's not what you're to consider. Mr. Collins wasn't under oath. Mr. Collins couldn't be cross-examined, just like his demonstration hearing. There were probably a lot of questions that everybody should have had during his demonstration as to whether or not it was going to be deceiving to you, how it was done, crouching, standing, or whatever. But we didn't have that opportunity because why? It's not evidence. He's not under oath. He can't take any questions from us. So I submit to you that you don't follow that type of stuff. You look at the evidence that's been presented from that witness stand and the evidence that's been submitted to you in court, duly evidence, and that's what you decide this case on. So back to 6 box shots in the back. Yeah, that's pretty significant, okay? That means that Dr. Shepler said that they all went from back to front, right to left, and some of them slightly upward, and the other ones greatly sharp angles, which she said was consistent with that somebody could be falling forward. Do you have Rippy's photograph?
Yeah.
So let's talk about, Mr. Collins is trying to say that, hey, we don't know where he is in the house, but you do have duly submitted evidence, not Mr. Collins' evidence, not Mr. Collins' testimony, but we have evidence that was testified to by an officer. And you can see in this photograph here, actually, there's his sock, has a hole in it. There's the other foot. And you can see kind of where he's placed there. You need Janae, so. And so what do we have? That's when Rippy came in. And if you look at the statement, and the statement is Mr. Meade saying that he's the one that rolled him over. There's no evidence in here. I think Mr. Collins wants you guys to believe that he was pulled or changed or pulled into the house. He's trying to put him out into the entryway there. There's no evidence of that. Don't be misled by that stuff. You look at the evidence that we've submitted to you.
Gary.
This is what bothers them. This is what bothers them because they know their expert, I won't show you, remind you of his, their experts' opinions on the trajectories don't work. He doesn't even consider the 3 shots in the mid-back where, guess who was aiming? Mr. Meade in his statement says, I was aiming center mass. I was looking through my sight, the red dot sight, and it was placed center mass. He was shot center mass. The first, one grouping of shots was center mass. The other grouping of shots, as Mr. Merkel had indicated, was lower. And you heard from Dr. Bauer and showed that. But let's look what else we have. Janae, and there's no evidence to refute Janae or Sharon. They both said Sharon meant how good a look she got, Janae, both of them are peering in when he was still on his stomach. He had not been rolled over. And they both said his hands were out. That bothers them. The trained observer, that's what they call him, the trained observer, never once puts in that statement as to where Casey Goodson's hands were. Not once. Not once put in that statement whether his hands were out or where they were. But we do have evidence. We have evidence from Janae and from Sharon, uncontroverted. Janae has his up here. So she's got him somewhere here. And if you look at Officer Rippy's, looks like his head is up towards that table. So I don't know what's trying to be fed to the jury, but I'm just trying to make sure that you guys don't get misled. And look, if I say something that you think might be off, go by your memories. Go by the evidence. You remember during the trial when we had a photograph up there of showing the distance of the 100 yards going all the way down the street, looking at Casey's from Sales to there. I don't know if you saw it, but Mr. Nolder puts up there that photograph and it's zoomed in. You're all looking at it. It looks like it's closer. Mr. Merkel got up here and had to zoom it out for you. Use your common sense. Rely on the physical evidence because, as Mr. Merkel said, the physical evidence doesn't lie. Now they can, Chris Korn. I mean, he testified. And you're going to see in the instructions, you can believe all, part, or none of a witness's testimony. You could say part of it. Yeah, I could think some of it might be truthful. Some of it might not be truthful. But he was there. There's no question about it because we had his GPS. We had that he was there in the neighborhood. Now, with the video from St. Matthias, we can see it was his van that was there. So there's no question. They aren't denying that he was there. But, you know, what's kind of interesting is that, remember the van that he's talking about, heating and cooling van. And he testified, once he went back into the neighborhood there, he's the one that pulled up close to try to see what was taking place. And it was after the fact. And it was after the fact. If you remember the transcript of Sheila Sanford, who was subpoenaed, ordered into court, wouldn't come into court, so they had to read her testimony from a previous hearing. But in that report, she said, yeah, there's this heating and cooling truck. When we made the turn, there's this heating and cooling truck there. And you know, and I'd seen it there all day. And then there's some question, well, what time did you get back from the funeral? Oh, I don't remember. Well, we know this didn't occur at 11:30, but that's when she told the officer she was there at 11:30 home. This is the type of evidence they want you to rely on. And there's somebody that did hear what Officer Meade said, and that was Officer Rosser. And he said what he heard, he's a trained observer. Sheila Sanford is not. And you rely on your recollection whether you're going to believe Sheila Sanford. But Officer Rosser, who was his partner, they worked with for a long time, worked on so fast. He said in his testimony, I heard 2 times, show me your hands, show me your hands. He never heard drop the gun. And do you think if he heard drop the gun, you would have heard that? You think that they wouldn't have asked him? So they come in here and they bring a transcript in from Sheila Sanford, and that's what they're going to have you rely on? Is this transcript of a lady that says she and her husband were making the corner and they saw, I don't know, Casey running? Well, running? Where was he? When in Mr. Meade's statement, he claims by the time he got down to the street that Casey was walking up to go through the gate. That makes no sense with Sanford. But that's what they want you to rely on. And by the way, what she said was, she didn't say drop the gun. Okay, or she didn't. So you listen and rely on your memories. Not sure, back to Chris Korn then. I think, you know, he didn't want to be involved in this. And there's, you know, even going through the voir dire process, there was a lot of people that didn't want to be involved in this. There's a lot of people that didn't want to be sitting on a case like this. He saw what he saw. He did come forward when he thought. What did he think? He did see something on TV from a prior hearing. And he didn't feel that what was being portrayed was accurate. He felt that they were portraying Casey as a gun-wielding.
Objection. Ruled closing argument.
That they considered him to be some crazy gun-wielding person. And all he says is, that's not what I saw. And in fact, what he said was, I didn't see a gun, but he came in here to just tell you what he did see. And if you look at the turn that Casey made, by the way, a continuous turn, unlike what he says, when he made the turn, as fast as he came around that corner, it's seconds going past Mr. Meade's truck. And immediately, as Corn's behind him, look how quick that. Corn would have probably seen something very similar as to what Jason Meade saw. Now, what did he see? He saw movement. Looked like he was singing. And we've heard Janae, he loves those AirPods. He wears them all the time. Was he riding in the car with the AirPods? We do know from Detective Howe that they were continuously paired. He said they were continuously playing. And remember, I asked him the question. They were continuously playing, weren't they, Detective? Yes, in his analysis. The YouTube. So Corn sees him moving. He says it was dancing. There was movement in that car. Now, what he saw, I don't know, okay? Because I guess he puts in a statement what he saw, but let's look at that. Let's analyze that. Let's analyze that statement because you guys, Mr. Merkel went over it a little bit. All these things, when you get that statement, I want you to grab that statement and you start listing everything that he saw while Casey was stopped. Go to the, I think it's page 8 or 9. He says, he's 10 feet away from me. I have this great view, the trained observer. I have this great view. And while he's there, before he makes his turn, there's an approaching vehicle. This is in great details, ladies and gentlemen. This is not a minor mistake. This is somebody that's already done something 30 days earlier. This is somebody sitting there maybe trying to put together his statement that's all justification. That statement, you read it, it's all his justification as to what he did at that house when Casey was going in his door. Says Casey's there, palm down. That's pretty specific. Approaches, I guess he's driving with one hand. He's going to make the turn with one hand. Palm down. And you saw I had Mr. Worley put the clip in. And, you know, this extended clip, you're talking about exaggeration. It'd make you think that this was a clip, a banana clip of some sort. I guess they call them magazines. You go, how in the world could he have ever seen this if he didn't see it? As Mr. Merkel said, he saw it at the scene after he shot him. 30 days later, he writes the statement. But you saw what Mr. Worley did. I had him hold it like this because if I'm making a turn past you, and if I'm pumping the thing, the butt of the gun's pointing out the other direction of the car. And that's when he says he's radioing. There's a guy waving a gun out here. Now, we don't have those radio transmissions, unfortunately. He knows we don't have them because it's signal. The marshals use the encrypted channel. We don't have any access to that, and he knows that. He can say whatever he wants. I did this, I said this, I did this. But there was only one person that responded, and that was Youngless. But he said, oh, everybody heard it. But everybody heard it. Well, don't know. Don't really know what all he, other than what he claims in a statement, is whether or not you're going to believe him. So he's like, what's going on here? We know that that is not true. And had we not had that video, this evidence would have been presented to you that Casey was stopped there. that Casey did sit there and he saw all these actions and stuff, unlike what Chris Korn's shown. But he sat there and all this movement of the gun, making him a bigger threat. Because if you read in his statement, he goes, one of the reasons he pursued him was because he was a threat to me and he was a threat to other motorists, leading up to the first step going towards his justification. First step to show why he's pursuing. Everybody, oh, this is a big threat. I think it was one person. Aggravated menacing, whatever, that's a misdemeanor. And they sat there and trying to say the other one, improper handling of firearm, that's not a violent offense. This all, Casey's pointing a gun over this. Now let's talk about the reasonableness, because it is reasonableness. How reasonable is he? Sales and estates, he's got his backup. Rosser works with and Yorkowitz, so fast. They're all so fast. So he's got his team. When they do these entries, they're all together. They all make arrests together every day. They work with each other. They know each other. They plan with each other. Yet he doesn't take advantage of that, and in his own words, speeds off. And you know, I suspect you, had not Rosser and them be there, the story might be different. Because the story morphs when there's a witness around that maybe can contradict what he's saying. There was nobody at the intersection except him. But what he did say was, I looked down the street and I said, hey, there he is. There he is. And read that statement. It's strange, but read the statement. There he is. There he is. And Rosser sitting there saying, I have no idea what he's talking about, a guy with a gun, but he couldn't see a gun. He couldn't even tell what the guy looked like. He couldn't say what his clothing or anything. And by the way, in the statement, he gives no description of anything when the car passes by, but no description or anything. Doesn't see a gun. But that somehow just set him into motion, because now it looks like something has changed. Is it a field interview you're doing? Or what are you doing? Are you upset about something? Are you just overly aggressive about something? And this is what you guys can look at, and you can make these determinations as to what was going on in his mind. Because that's what they want you to do. Look in his mind. See what his subjective intents were, what he knew or didn't know. And we talked about this in voir dire, how somebody reacts, how somebody acts, what they do. You can look and see and come up with using common sense. Not speculation, but common sense. So all this training, and he takes off. He doesn't even do that so fast. They work together. Leaves the team behind. And he reads in there, it says, I accelerated down the street. Over what did he see? He says in there was no running. Nothing had changed. There was no thing in his statement Casey was threatening him, threatening anybody, pointing a gun, yelling. You remember Youngless when he said, oh, exigent circumstance. This is what I look for. If they're yelling, screaming, pointing a gun, or it's a combine thing, or there's a robbery or a rape or something serious that we have to get there. We all understand that. You use your common sense. Because remember, this is your call to make. Not Scanlon's and not Stoughton's. This is your call to make.
Councilman approach.
Okay, and I'm sorry. I just want you all, I will agree with Mr. Collins on this. You make your decisions up as after you get back there and you start deliberating with each other. And you all converse with each other, check on each other's mind. You ask yourselves, what is going on here? Is this even reasonable? Is this even what is going on? Did Casey even know anything? But I want to tell you this. He brings up the CCW, and if you remember what Sharon, this picture, you can see it's something a selfie young person uses. It's not pointed, it's pointed at the phone. And you can see off to the side, it's been cropped. You can see off the side because Sharon said, I think it was Destiny that was in the car with him, but they've sent you a cropped version of it, of this selfie. Cut her out. So what did she say? I was concerned about this case having guns. But you know what? He had his carry concealed. He said, I'm concerned being a young black man, having a gun. What could happen? He goes, Grandma, don't worry.
Objection, Your Honor.
Overruled, closing argument.
I know what to do if I get stopped by the police. Because I've got carry concealed. I put my hands up, I've got carry concealed, and I'm legal. Ladies and gentlemen, I just want you to, because we don't have enough time to go over things. I'd love to address everything that he went through. But we have to split ours up to a rebuttal and to address. But I ask you to rely on all your information, everything that you've got. Hold them to their burden. Don't let him shift that burden over onto us. This is their burden. This is them. If you go back there and you say, I don't know what happened, it's guilty. If you go back there and say, hey, Schroyer and Merkel didn't show me this, we don't have to. That's them. They're to present the evidence to you for justification. We put evidence in, but they're the ones to present the evidence to you for justification, not us. We've met our burden by his own statement that he met everything there. And I leave you with this. Ask yourself if this even makes sense. 12 o'clock in the afternoon, Friday, carrying a bag of subs. What was going on here? Casey's going inside to have lunch with his family, but first shoot an officer and then go in and sit down and eat lunch? Is that what was going on here?
Overruled, closing argument.
You think that that's what took place here? I'm going to go and shoot a police officer and then go and sit inside where my family was, where my baby D, who he knew was there, and then sit down at the table and eat lunch for everybody to do.
Ladies and gentlemen, back to you, the jury instructions. Your initial conduct upon, it's the bottom of page 10 if you didn't. Your initial conduct upon entering the jury room is important. It is not wise to express immediately a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you later decide you were wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement. If you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. Before you can find the defendant guilty or not guilty, you must unanimously agree on your verdict. On behalf of the public and the parties, the court expresses our appreciation for your services in performing this important public function. After your verdict is returned, you may discuss the case with anyone, but you are not required to do so. Whether you discuss the case with counsel or anyone else after you are discharged is a matter of your own free choice. When you retire to the jury room, you should select the foreperson. The foreperson will be responsible for the exhibits and the verdict forms and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast their vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose to anyone the status of your deliberations or the nature of your verdict. If you have a question, write them on a piece of paper and give the
paper to the bailiff. When all 12 of you agree on a verdict, all of you should sign the appropriate verdict form in ink and advise the bailiff by turning on the green light. You will then be returned to the courtroom. Alternative jurors were selected to serve in the event of any misfortune befalling a member of the panel. Each of you will remain as an alternate member of this panel until your jury has reached a verdict. If your service is needed, you will be in panel with the other regular jurors and deliberations will start anew. You may return to the general jury room to await further instructions from the court. Since you are still an alternate juror, you are not to discuss the case with anyone and you're not to tell anyone how you would vote on this case. We'll get you all the evidence and everything. And if you guys want to see the guns, I do not allow guns to go back with ammunition. So we can do, if you want to see the ammunition, we'll take the guns out of the jury room and those kind of things. All right.
Bring your papers.
Chairman, here's the verdict form.
Well, that's.
Guys all have seats. Did you need to put anything on the record or
We
on?
do, Your Honor.
Okay.
Absolutely. Your Honor, at this point in time, there was a misstatement of the law by Mr. Schroyer that couldn't be any blatantly more opposite. In fact, when we went up there with Mr. Merkel, we indicated that you can't do what he was trying to do because it's a misstatement of the law. The law says they are not to consider any perspective of Casey Goodson. So when Mr. Schroyer gets up there and says, you got to ask yourself, why would someone go to Subway? Why would someone then shoot an officer and then go in and eat lunch? He is precluded from doing that. It's prosecutorial misconduct, and we have to ask for a mistrial. I don't know why they go there. They know, I think they know the law. You cannot speak to that. You cannot speak to what was in Casey Goodson's mind. They're precluded from it. That's the law. They've been in a trial like this before and they didn't do it. They did it now. So I don't believe it's out of ignorance or they don't know it, but that cannot happen what just happened there, Your Honor. We have to preserve the record for a mistrial. It's prosecutorial misconduct. It's a blatant misstatement of the law, no matter what angle you're coming from, Your Honor.
Your Honor, it's not a misstatement of the law, first of all. This case deals with credibility. This deals with the credibility of his statement and whether or not what he says in that statement is true. And what's in credibility is, did Casey Goodson ever turn and point the gun? You can't separate this out. Otherwise, what are we doing? He sits there and says, I didn't do it, and that's the only thing I could use in a statement. His credibility of the statement is an issue, and they're allowed to sit there and whether or not I read a portion of the jury instructions, they're allowed to consider, okay, whether or not his statement, what he said there wasn't true. We can test the veracity of that. And part of it is whether or not it makes common sense, his statement, and whether or not, and the jury's allowed to sit there and look at things like that. So,
One person at a time.
I apologize. Are you through?
yes.
Okay. Your Honor, I have no disagreement with what he just said, but that's not the law. There is no law on credibility. There's a law called justification. And in the jury instructions, Your Honor, it outlines exactly what you can and cannot do. And it precludes you from making an analysis and an argument about what was the intent or Can I finish, Tim? What the intent of?
Your Honor,
I mean, I don't understand what you guys don't understand. One person speaks at a time.
I understand, but he's addressing me for some reason, like I'm going to rule on it. I don't know.
Come on. Anything else?
It's a direct violation of the law.
All right.
We disagree, Your Honor.
Okay. I'm not declaring a mistrial right now.
Hey, Megan, everyone has our phone numbers, right? Thank you so much. Hey, Beck, thank you so much. Carmen, thank you.
Do you want to check the evidence before we send it
Probably
back?
should, yeah, I probably should.
Not after that, not after that.
Yeah, where's the blank computer too? Need to look at that and make sure it's blank.
Rachel has that.
Well, hopefully it's blank. Did you check it? Did you check it? The blank computer that you sent back with the jury? Did anybody check it?
I didn't, I haven't been in
Okay,
possession of it, the court's got it.
Yeah, it was brought to the
It
court.
was brought to the court.
You know, we didn't bring it to the court. The prosecutor's office brought it over.
You're the. You are responsible for it, Kenny, not us.
I understand.
Rachel.
You guys have your exhibits gathered?
Yeah, well.
It's gonna take us